Will you read?
He's got the
what
clicker.
we're-
Well, you set it all up, Troy.
We're checking to make sure that the board can hear her.
What?
I'm not sure.
Mr. Choi, you set the setup in there, right? Yeah, so who's controlling the sound on that side?
What will be the sound and
Who's the sound guy?
it's a third party vendor.
Who?
Third party vendor.
You mean KOCT? They don't adjust the sound. Who's the party vendor that you worked with over there?
I don't know.
Who's adjusting the sound? Like Mr. Soskins when he raises the clicker over there. The clicker was here, now it's moved. Where's it at? Who took the clicker that was here at 1:30? Okay, so are you going to use that for this side?
It's just in case there's issue. I mean,
And you're going to be here the whole time? And so on the other side, who is the vendor that's handling this technology that's our in-house technology?
I don't know. I have to ask him.
Okay, it's documented that I can't see my board colleagues, I can't see staff, but we know we've seen Mr. Soskins increase and decrease the volume on that side of the room. So, and there's these cameras here, 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 and I hide for my privacy. So I continue to be harassed by Officer Matt Hernandez and Mr. Is it Osaka?
80%.
I don't remember
The
how
police officer
But,
is
you know, they're just doing their
the
job.
security
They're
officer is
told
laughing.
to do what they have to do.
He looks like he's mocking her.
Well, they weren't responding even when they hear because someone's over there
It is
lowering the
3:36,
sound. I want to know who is in
and
charge
the temperature
of the
in
sound
the
over there.
room is 80 degrees Fahrenheit.
Thank you. I'm going to call the Board of Directors meeting, regular meeting of the Board of Directors of Tri-City Hospital to order. It's 3:35. A roll call vote. Director Sterling,
Present.
Director Horton,
Here.
Director Anderson,
Here.
Director Coulter,
Here.
and Dr. Kellett,
Here.
and Director Shalak.
Here.
And Rosemary Reno, Director Reno's here. And we'll have the Pledge of Allegiance at this time, if you will stand. Repeat after me, thank you. Allegiance to the flag of the United States of America and to the republic.
Kathleen has walked out the room. The security officers are following her every move. Back in the room.
Public comments announcement. Members of the public may address the board regarding any item listed on the board agenda at the time the item is being considered by the Board of Directors. Per Board Policy 10018, members of the public may have 3 minutes individually to address the Board of Directors. Note that members of the public may speak on any item not listed on the board agenda, which falls within the jurisdiction of the Board of Directors, immediately prior to board communications. And if you wish to speak to any item, we have yellow forms on either side of the room. Security on this side has some, and Facilities Vice President on your left side has the forms that you need to fill out and indicate which item you wish to address. Bring them forward or send them forward to our Executive Secretary. Thank you. I will proceed then with number 11. And I'm sorry, and it's a report out from closed session that the board took in closed session item 11, right?
Right, the only action taken in either the closed sessions of the special meeting or the regular meeting was the board voted to release the information that it considered on April 28th, 2011 under item 5, which was under item 5A regarding the motion that was passed at that time to exclude directors Horton and Sterling from closed session for a 6-month period. I do have an excerpt of the minutes that will be available as a result of that motion.
Excuse me, Director Reno. With respect to that item, can you hear me?
Yes.
Can you acknowledge I can't hear you?
Yes.
Thank you. The setup that you have is flawed, nevertheless. I'm letting you know I've not received any of the materials that were handed out by Mr. Lawyer or to date, any items related to April 28th or that was discussed in closed session. And I want to clarify, are you referring to item 5A or which item are you specifically referring to that is the release of April 28th documents?
It's 5A, no, it's, hold on just a second. It's actually 5G. Okay? And for information, for your information, the only information we don't have information on April 28th. That's the attorney. That's what the attorneys have.
5
My
packets.
understanding is that the information that
They are cutting
is going to
Kathleen
be
off
made
and
available under
enabling
item
her to
11
speak.
has been made available. There's one page that has not yet been made available because I didn't know if you were going to release it today. I have copies. It's just one page. It is on its way over to Director Sterling, and it is just a report, one paragraph of the action taken on April 28th in the closed session that was authorized to be released.
Mrs. Director Reno, can I ask Mr. Mosher a question or shall I ask it through you?
Yeah.
What?
Go ahead. Ask.
Can you make sure that your speakers are close enough for your volume to be translated in this room? And would you also let me know if Mr. Soskins is manipulating the sound over on your side? Because Chu here doesn't seem to know who it is. Well, I can't hear you on this side, so somebody's doing something, okay?
They are harassing Kathleen.
On the April 28th, on April
I will have that checked out immediately.
Thank you. On April 28th, related to this item 5G, on April 28th, Mr. Horton and I were present, and there was 5 members of the board were distributed a packet. Is that packet the same thing that we're now getting today?
That packet, anything that was in that packet, the board has authorized release of. I believe that some of what was in that packet is being just made available if we can get to item 11.
And has this item also been, this packet that was April 28th, have you distributed to the grand jury or any other outside agency? District attorney, etc.?
I certainly have not. I have not been asked to do anything with respect to the grand jury.
Then I'm asking if Mr. Stein, who is staffed by this board, and by Mr. Anderson with legal counsel, distributed that packet that was in the April 24th closed session to the district attorney or the grand jury.
I think you should move to item 11.
Okay, we will move to item 11. And we will have discussion of our report that was taken. Actually, we'll have a report that was taken in closed session, and we're going to give you that report now in open session. We need to have you Should we proceed first, Mr. Mosher, with Mr. Anderson, or how should we proceed with this item?
Madam Chair,
You customarily have a motion before you consider an item?
Yes. Say it again, please.
You customarily have a motion before you consider an item. So you would normally ask for a motion at this point before you have a presentation, but you can do it either way around.
Madam Chair,
Sure.
I,
Director Horton.
in abundance of caution, I'm going to recuse myself from discussion and voting on this item.
On that item 11? Okay. Will you come back in? Mr. Mosher, how do we proceed with the board?
Well, he certainly can recuse himself. This doesn't have any financial impact on
It's freezing
on
cold in
him
here.
or on Director Sterling, so I don't think they have a Political Reform Act problem, but it's really up to them whether they'd like to recuse themselves.
Okay, fine, thank you. And now I'm going to ask for a motion for item number 11. Discussion regarding proposed censures of directors Horton and Sterling and further sanctions.
Or you may hear the evidence first, and it may be that you want to hear the evidence
I
in this
beg your
case.
pardon?
It may be that you want to hear the presentations
Yes, that's what I was
first
asking. I think I didn't
before you...
propose my question right. Okay, thank you. Before we do any voting, we'll hear all the measures. Thank you, Mr. Anderson.
Right. Chairperson Rosemary Reno and board members and members of the public, my name is Larry Anderson. I'm the Chief Executive Officer for Tri-City Medical Center.
A minute, Larry, we have to check your
Not working?
speaker. Can you hear now?
Okay, so I got to be closer.
Can you hear Director Sterling?
Okay, what I'm going to do is make a presentation to everyone present here, obviously, and it's going to be in two parts. I'll do the first part, and the second part will be presented by Allison Borkenheim, who's got to be in the room somewhere, I'm sure. There she is. And she is Senior Labor Counsel for the hospital. What I'm going to be sharing with you and what is contained in the packets of information that should be on the back table is information that was shared primarily with the board at the closed session on April 28th and was the basis for the board's action regarding Directors Horton and Sterling at that time. So I have a statement here. It's included in full text in the back. Allison's statement is included in full text. And also there are evidentiary documents, including affidavits and other documents that we assembled and provided to the board in preparation for its deliberation on April 28th. It is time for the world to learn the stories of two directors whom the public unwittingly elected to the board of Tri-City Healthcare District without knowledge of their intent to deceive the public. The deception comes in the form of blatant and repeated violations of their duties of care, loyalty, and obedience, duties owed by any board member of any organization. The breach of those duties comes in the form of repeated disclosures of information provided to them in closed sessions of the Board of Directors. This conduct is illegal under California's Brown Act. Moreover, beyond those impermissible disclosures, these two board members have repeatedly falsely represented facts regarding the hospital in order to mislead the public and, in some cases, which will be presented, have worked in direct opposition to the best interests of the institution that is Tri-City Medical Center. The public should be as outraged by this conduct as I am. The acts I'm going to discuss are not only illegal, they are despicable, have no redeeming purpose, and cry out to be aired publicly so that the public is not shielded from the clear misconduct of its elected officials. The very sad commentary on these facts is that they are occurring at the very time when the organization itself is reaching new heights daily in profitability, quality of medicine, and acclaim throughout the community, the county, and the state. For example, just last week, we received the Healthcare Champions Award for Excellence in Management Leadership. Nevertheless, such recognition is blurred by the following misdeeds of our directors. First, I will recount and prove convincingly what I observed and know, and then Allison Borkenheim will follow with further details, and then we will jointly answer the board's questions. First, the facts with regard to Director Horton. In early April of this year, Director Horton called Dr. Folker and shared the entirety of a closed session conversation with him. I have an affidavit from Dr. Nielsen in which he recounts an April 3 discussion with Dr. Folker, which undeniably establishes Director Horton's complicity and guilt in the matter. Sharing of closed session materials illegal and a matter for referral to the grand jury. In January of this year, Director Horton contacted Gigi Gleason. I know I saw Gigi in the audience, and many of you know her well, and told her that it was his intent to share any board materials, either open or closed session, with Director Sterling, if those materials had not been shared with her by me or by the board secretary or other board members. This statement violates the sanctity of the boardroom and the legislative process and makes a mockery out of the law. Thereafter, on April 1, I wrote an attorney-client privileged email to 6 board members, including Director Horton, but not including Director Sterling. I did not include Director Sterling on the email chain because I was preparing the board to address an important issue regarding Sterling's qualifications to participate in board matters. Horton shared that privileged communication with Sterling and her attorney, and it was promptly filed in a temporary restraining order action filed against Sterling by the district and its employees. Director Horton thereby shared privileged and confidential board communications with opposing counsel. This is also a violation of board policy and the law. Apparently undaunted by this act of malfeasance, he and Sterling together called Paul Sisson of the North County Times and told him that a board meeting scheduled for April 7 was being held for the sole purpose of disqualifying Sterling from sitting on the board. Sisson questioned Horton regarding how he knew this, and he sheepishly lied that he had seen a draft agenda of the meeting prior to its issuance. I have confirmed with Karen Nielsen, the only person who could possess such authorized draft, that he did not see any draft. So he not only shared privileged confidential information with the press, he lied about his source for the information to the press. His actual source for that information was my privileged April 1 memo. Again, these are unauthorized acts and a breach of the attorney-client privilege. I have an affidavit from Kelly Moores, formerly the manager of public affairs, recounting not only her discussion with Mr. Sisson on this matter, but recounting the clearly established Brown Act violations by Director Sterling at the March 31 meeting. This item was put on the agenda for closed session items, and thus there was no way for Mr. Sisson to know the substance of the agenda item unless confidential information from the closed session had been disclosed by Horton and Sterling. Such disclosure is a violation of the Brown Act, the statute that governs the operations of public agencies in the state of California, and is, among other things, referable to the grand jury. Such conduct is illegal, and the grand jury can remove the board member for willful misconduct under California Government Code Section 3060. At the March 31 meeting, despite numerous warnings, she and her attorney continued to confer, share information, intimidate administrators, and in the course engage numerous violations of the Brown Act, not to mention hospital policy. I will now turn to Director Sterling's individual acts of malfeasance and breach of her duties of care, loyalty, and obedience. Sterling has been acting as a double agent, on the one hand, purporting to represent the hospital's board, and on the other hand, working in collaboration, though in discreet fashion, with counsels and others suing the hospital for many years. In the process, she has shared attorney-client protected, attorney work product, statutorily privileged, and closed session privileged information with parties adverse to the hospital. I could not imagine a more reprehensible and despicable violation of our policies and the law than to take information you are provided in confidence and share it, unknown to this board or administration, with parties pursuing claims against the hospital. Sterling also assisted Dr. John Young in litigation against the hospital, which Allison will address in further detail. Dr. Young was represented by attorney Ron Kozat in those matters. Kozat also represented Dr. Mariah in a breach of contract case against the hospital. In discovery, Kozat asked certain questions, which were then asked by Sterling during board meetings. Sterling also made comments in open session, sharing closed session discussions, which gave the appearance that the district had made certain promises to Dr. Mario. Kozat sought to introduce those very statements into evidence against the district. This is yet another example of Sterling attempting to assist lawyers who oppose Tri-City.
They're trying to
Interestingly,
bully
Kozat is now working
Kathleen.
with Leon Page in Page's lawsuit, or proposed lawsuit, I should say, against the hospital related to the exclusion of Sterling and Horton from closed sessions. Similarly, at the last board meeting, Sterling asked questions propounded by an opposing party in litigation with Tri-City IPA.
It seems
The
like she's
questions were posed to
uncomfortable.
the district's external auditors and were so distinct that it would have been impossible for her to formulate those questions without having had contact with opposing counsel. Recently, in conversations with our outside labor counsel, former Vice President Scheherazade Rizvani shared that she had been working with Director Sterling, who was in contact with counsel adverse to the hospital, and therefore knew what plaintiff's counsel suing the hospital would accept in settlement of claims they had against the hospital. Such conversations are well documented in correspondence to me from our counsel's office. These conversations between Sterling and plaintiff's counsel were never authorized or sanctioned by me or this board. More importantly, they undermine the district's ability to defend claims against it and to protect the public fund. Even I am not allowed to speak with plaintiff's counsel, not because I am a lawyer, but because I am not the hospital's lawyer. And no communications are permitted other than between parties directly or their counsels, and Director Sterling is neither. I further have direct evidence, which is still being collected, but which we already possess much of, which reveals an unending trail of deceit and espionage by Director Sterling in collaboration with plaintiffs' counsels and their representatives going as far back as 2004.
They're
or
trying to
3.
attack her
Not sure which,
character.
but it's in that time period of 2003 to 4, sharing attorney-client protected work product protected and closed session information with counsels adverse to the hospital. Allison will present that evidence directly. Allison will speak next. But when she is done, I request a motion from the board disqualifying both Sterling and Horton from any closed session participation for the remainder of their terms. I have placed copies of some of the evidence we have gathered on the tables in the back for public review. I know this is a difficult decision for you. You are likely to be criticized for taking this action, as I'm sure I will. However, these violations are egregious, well documented, and go to the heart of our efforts to run this hospital. The acts are cowardly and despicable. They are also dangerous to the future survivability of this institution. Now I'd like to introduce Allison Vorkenheim.
You hear me?
You might pull it closer to you, Allison.
Does that work? Is that better? Okay. Chairperson Reno, other members of the board, and members of the public, my name is Allison Borkenheim. I am Senior Counsel of Labor and Employment for the district. I advise the district on employment laws, but also attend to other matters including litigation, certain business transactions, and confidential matters. I've been asked to make a statement tonight informing the public of those events of which I have knowledge that are in addition to the events recounted by Larry Anderson, and to provide some background for the legal positions taken by the district and the members of the board. Since working for the district, I've become acquainted with certain courses of conduct undertaken by Directors Kathleen Sterling and Randy Horton. Sometime in April 2011, Mr. Anderson informed me that he learned that Director Sterling had consulted with attorneys who were engaged in litigation against the district. It was his opinion and the opinion of others that Director Sterling's express purpose was to aid those attorneys in their cases against the district. In order to confirm the information given to me by Mr. Anderson, I undertook to contact Linda Elsner, a paralegal in San Diego County. On May 3rd, 2011, I met with Ms. Elsner at her current place of work in the Rancho Bernardo area. During my meeting with Ms. Elsner, which lasted approximately an hour, she confirmed that Director Sterling had actively assisted her in litigation matters pending against the district. Specifically, Ms. Elsner explained that she had previously worked for an attorney whose offices were located across from the Vista Courthouse. In June 2003, Ms. Elsner was working on a case filed by Thomas Corellis against the district. Ms. Elsner confirmed that she had been at the Vista Courthouse pulling documents in connection with the Corellis case. She was helping the attorney with whom she worked to prepare for an opposition to a motion for summary judgment that had been filed by the district. Ms. Elsner informed me that while at the courthouse, she was approached by a woman who inquired whether Ms. Elsner was working on a case against Tri-City. Ms. Elsner told the woman yes, at which point the woman offered assistance to Ms. Elsner. Ms. Elsner learned that the woman was Director Sterling. In connection with the offer of assistance, Director Sterling told Ms. Elsner that as a director of the district, she had information that could assist with a case, information that other people did not have. Ms. Elsner further informed me that after the conversation at the courthouse, Director Sterling accompanied Ms. Elsner to the attorney's office across the street. Apparently, Director Sterling informed Ms. Elsner that she should review the Joint Commission report regarding Tri-City. Director Sterling indicated that the report showed that the district had problems, and the report might help in the case against Tri-City. In fact, although the district prevailed on its motion, a review of court records indicates that the Joint Commission report was attached to Corellis' opposition to the district's motion for summary judgment. Ms. Elsner further informed me that she asked Director Sterling why she would assist someone who had a case against the district. Ms. Elsner stated that Director Sterling said that it would ultimately be good for the hospital. I had subsequent conversations with Ms. Elsner, which led me to believe that Director Sterling sought to assist Ms. Elsner and the attorney for whom she worked in other matters against the district. Ms. Elsner also informed me that Director Sterling had assisted Dr. John Young in preparing pleadings in matters in which Dr. Young was adverse to the district. Ms. Elsner told me that she knew this to be the case because Ms. Elsner also assisted Dr. Young at Director Sterling's request. Ms. Elsner formatted the pleadings for him. Dr. Young was represented by attorney Ron Kozak, who's now working with Leon Page in matters against the district. Moreover, Director Sterling actively assisted Dr. Young during his trial against Tri-City. My colleague Matthew Soskins observed Director Sterling at trial and confirmed her conduct in a sworn affidavit. Additionally, Director Sterling's conduct at trial of Dr. Young is confirmed in a sworn affidavit by Christopher Freestedt, the district's outside counsel in that matter. Mr. Freestedt observed Director Sterling conversing with Dr. Young and confirmed that at no time during the trial did Director Sterling attempt to assist the district in its case or attempt to advocate on behalf of Tri-City. Direct observation of Director Sterling also indicates that she assisted plaintiff Mary Elise Curley in a case against Tri-City. At Ms. Curley's trial against the district, also attended by Mr. Soskins, Director Sterling sat directly behind Ms. Curley during the legal proceedings. Director Sterling carried a stack of papers with her and actively interacted with Ms. Curley. Director Sterling had been in the closed sessions of the board meetings during which Tri-City's litigation strategy and counsel's opinions regarding the strengths and weaknesses of the case were discussed. The bailiff at trial also informed Mr. Soskins that Director Sterling stated that she was there to, quote, prevent Tri-City from doing anything illegal, end quote. This information is also confirmed in the sworn affidavit from Mr. Soskins. Despite reports in the press to the contrary, there is legal precedent for Tri-City's exclusion of Directors Sterling and Horton for their misconduct. I will not go into a long litany of legal history and authority, but I do want to clarify that although exclusion is not expressly enumerated in the Brown Act, other legal precedent provides Tri-City with such authority to act to punish and discipline board members for misconduct. Importantly, the disciplinary power of all elected bodies is long-standing and is derived from the assertion of parliamentary supremacy in England after the Glorious Revolution in 1688. Our founding fathers incorporated such power in the fabric of the U.S. Constitution, and such power to punish was found to be inherent in even, quote, the humblest assembly of men, end quote, in 1997 in Whitener v. McWaters. Extending the power to punish and discipline members, the Whitener case confirmed that public boards, like Tri-Cities, enjoy wide latitude to censure their members. In that case, a publicly elected Board of Supervisors was permitted to censure one of its elected members and remove that member from all committee assignments because of his abusive conduct. The court also found that such discipline was a core legislative act for which the board members enjoyed absolute legislative immunity. Indeed, just this year, the U.S. Supreme Court upheld a censure of a legislator in Nevada Commission on Ethics versus Kerrigan. In so doing, the court confirmed that the procedures for voting in legislative assemblies pertain to legislators not as individuals but as political representatives executing the legislative process. The court rejected the idea that the First Amendment confers a right to use the governmental process, quote, to convey a message, end quote. That is, the dais is not a platform from which individual board members can assert First Amendment rights. Additionally, California's Health and Safety Code, the statute under which healthcare districts were created, gives wide latitude to a district to act as it deems necessary in order to execute its powers and duties. Specifically, Section 40702 of the Code provides that a district, quote, shall adopt rules and regulations and do such acts as may be necessary or proper to execute the powers and duties granted to and imposed upon the district by the division and other statutory provisions, end quote. A comprehensive compendium of legal authority can be found in the district's opposition to Kathleen Sterling's demur to the district's complaint in the restraining order matter now on appeal. And that can be found on the back table, as well as a copy of this statement and affidavits mentioned here. Thank you.
Thank you very much.
Are there any questions from the board? You have a package of information in front of you. By the way, all the same documents are made available to the public on the back table.
Have any questions?
I have one question, and I had mentioned it earlier upstairs to you that I had been told that Ms. Sterling told Gigi Gleason that Horton would give her anything, or give her all the information.
The photographer is making me uncomfortable in
Do
this
you,
room.
Can anybody clarify, or do you know?
I have a different recollection of what
Okay.
I met personally with Gigi in my office. What I reported in my report is what I remember her telling me. If she says she said something different, then we have a difference of recollection of what was said. Although that difference doesn't seem like it would make any difference to me.
Okay.
Because whether it's Sterling who said Horton told her, or whether it's Gigi who said Horton told her, Horton sure told somebody.
Well, I don't disagree in relationship to the legal matter where the memo was to the board members, but not to Director Sterling, and it did end up in her court case. And actually, I was out of town when that happened, and not that we get into feelings of insecurity, but I knew that I had not done that, but I felt that perhaps someone would think that I had done that just because I look at myself as a minority member on the board, and I have concerns at times that you get the wrong impression. So, but it came out the other way, so that's fine.
I think in administration, we knew immediately where the disclosure had come from.
I'm not aware that we have any we have our own right to our own opinions, which we can express, but I don't really feel that you're a minority on this board. In fact, I think you're one of the collegial people on the board.
I tried to do that. I do also think that way, so.
I would certainly agree with what Mr. Sterling just said.
Okay.
Are there any, is there any other discussion? Okay.
Well, yeah.
Okay.
I've heard parts of this before, but not in such detail, and it's a lot for me to digest, so I'm sure it must be difficult for members of the public, and so I would ask you to really read it look at it, tell everybody you know. Because, you know,
Sorry.
so, this is difficult for me to digest, and I've been hearing bits and pieces of it all along. Can you hear me now? Am I turned on? What's wrong?
You need to come closer to the
Okay, so, again, difficult for me to digest all the details here, but I would suggest that members of the public do really look at it and really pay attention to what's going on here, because this is really important information. It's illegal activity by somebody that perhaps even some of you elected to hold this place dear and safe for our community. And as troubling as it is to be up here and to have to, you know, I mean, this is an elected position. When the public doesn't know why Tri-City has such a, you know, whatever the words they like to call, dysfunctional board, I think is what we hear. You know, when you say dysfunctional board, that includes everybody up here. And unfortunately, it's not everybody up here, and this is proof of that. And it's also proof of why, for 12 years, maybe a little more than 12 years, this hospital has been impeded in its forward motion by mostly one director. So, you know, that being said, and then we're going to make some decisions here today, and you're still, as members of the public, going to be sort of looking at this and wondering, you know, is what they did really that bad? Can you really prove it? I would